Hey, welcome back. I hope you got a chance to see the rocket launch. That was a geek out moment for me. Um, I just remember when the old rockets took off, the Apollo missions and stuff, and then the space shuttle ones. It was kind of cool. It's nice to see one leave from the United States again. Um, yeah. Um, Hope all is going well. We're almost done. My dad always said it's not how you start, it's how you finish. Today we're going on to Article 3, which is the courts. It's confusing, and they use a lot of Latin words, um, and just to make it sound more sophisticated, I'll hopefully turn it into English and make it kind of understandable. Just because I want you to have a basic knowledge of how the Supreme Court works, and of course, just the federal court system in general. I found this. I mean, well, I bumped into this, which is kind of near and dear to us.
Social distancing protects against the spread of coronavirus.
It means avoiding groups, staying at least 6 feet apart from others.
But just because we're at arm's length
doesn't mean we're alone.
So they reissued the More You Know stuff, which is kind of fun. Don't forget about the website if you're confused. We're saying that makeup has to be done by the 12th. And then the 15th we're wrapping things up. So because you guys graduate, I think on the 18th or something, and we have to have all the grades before then. So the end is near. I really hope high school goes better for you guys. I can't imagine it won't. I shouldn't say that. Anyway, let's get into this. So, beautiful building. Like I said, out of all the buildings in Washington, D.C. that are government buildings, this one's the newest. I use this intro. It's wicked old, but they say certain things about the Supreme Court. They say things that I want you to hear about why the building looks the way it does, how they judiciate. That's a fancy word. But yeah, let me hit it.
Mr. Chief Justice, and may it please the court. Mr. Chief Justice, and may it please the court. The government concedes that the destruction of documents in anticipation of a proceeding was not a crime in the fall of 2001, based upon
something different is going on here than what goes on in the Capitol building or in the White House, and you need to appreciate how important it is to our system of government.
That's the Chief Justice.
This is the highest court in the land, and the framers created it after studying the great lawgivers in history and taking a look at what they thought worldwide was important for the judicial branch to do.
I put in as much blood, sweat, and tears on the little cases as I do on the big ones. We don't sit here to make the law, to decide who ought to win. We decide who wins under the law that the people have adopted.
You will be surprised by the high level of collegiality here.
If there are 4 of the 9 of us who want to hear any of these cases, we'll hear it. We're here to decide things. The job is to decide. We decide.
Why is it that we have an elegant, astonishingly beautiful, imposing, impressive structure? It's to remind us that we have an important function, and to remind the public, when it sees the building, of the importance and the centrality of the law.
I think the danger is that sometimes you could come into a building like this and think it's all about you, or that you're important. And that is something that I don't think works well with this job.
It's an old video because a lot of those justices aren't even on the Supreme Court anymore. But Sandra Day O'Connor, she's the first woman to be appointed by Ronald Reagan. But it's great because it talks about the building and why it looks the way it does. And you probably don't know much about the Supreme Court. This is probably the branch that you know the least about, and it's almost designed that way. It's designed not to be flashy. They are lifetime appointments, and they don't have to worry about getting reelected, so they don't have to make public appearances and try to win votes and stuff like that, which is, we should never allow that to happen. And they, once they're on the court, they're there for as long as they want until they retire or they die. And that way they don't have to sway with public opinion. They don't have to do what's popular. They do what's right. And that's the beauty of our system. And it works. It is a beautiful building. It's right across the street. So where the visitor center is going into the Capitol building, if you're looking out towards the Redskins Stadium there, Washington Redskins, you on the right-hand side is the Library of Congress. Make sure you go in there. It's a beautiful building, and then on the left is the Supreme Court. So this is what it looks like on the inside. They don't allow TV cameras or television cameras or anything like that, and they record when they have a hearing, but they put it out afterwards. And actually, during the coronavirus thing, it's been the first time that it's ever been done live. They've been actually holding them live in virtual, which is kind of cool. But again, they only take they take 80 cases, the most controversial cases. They don't take you're not going to go there for a speeding ticket. What they take is if there's a problem with the law, and if Congress passed a law that you can't have long hair, and it gets signed into law by the president, they start arresting people with long hair, and you get arrested because you have long hair, you are guilty. And the lower courts will find you guilty. But what you need to do is appeal on the basis of the Constitution, saying they don't have a right to tell you how to wear your hair. And that's it goes to the appellate courts, and then if it's really controversial, then the Supreme Court grabs it. And that's the last appeal. The only people that can overthrow a Supreme Court decision is the Supreme Court itself, and they've done it. Plessy versus Ferguson said that segregation was okay. And then Brown versus Board of Education, 70 years later, said it's not okay. So this is a video I really just found this video. A look inside the building, and because the tour, they bring you in the door, they bring you right where this curtain is here. It's my little fancy thing. This is it, and then you walk back out. You don't see much. This is the old chamber, which is they used to be in the cellar of the Capitol building until the 1930s. And that's where the Supreme Court, worked. So all 9 judges sit there behind this desk, and some of the best lawyers in the country will argue the case before them. They're the constitutional lawyers. They're the best and the brightest. A lot of constitutional lawyers end up becoming justices, like Ruth Bader Ginsburg, the notorious LBJ. She was a big constitutional lawyer that fought for women's rights. She probably did as much for women's rights as Susan B. Anthony and Cady Stanton and stuff, which was kind of amazing that she ended up on the Supreme Court. That's why she's so famous. And there's a movie on HBO. It's probably on Netflix. Called On the Basis of Sex. You should see it. It's her story, what she went through. I didn't mean to do that. Go back. This is what happens when you get old. This is going to happen to you too. I opened these because I just wanted to be able to do it smoother and faster with you. So much for that.
Architectural plan to try to make the appearance of the court feel monumental, and to give the sense that there's important things happening in this building.
We're in the Great Hall of the Supreme Court, about to enter the most important courtroom in the land. The Supreme Court's impact is almost immeasurable. Few ever had the chance to get behind the scenes of this iconic building. Only 2 pictures exist of the court actually in session, and those cameras were smuggled in the 1930s. But on the 75th anniversary of the High Court's home, we gained rare access to this place.
It's sure to surprise many people that this building's actually the permanent home of the Supreme Court's only 75 years old, which is kind of young in relative
This is
terms
10 years
to
ago.
many of the buildings here in
Right,
Washington.
exactly. And that was one of the tasks that was assigned to the architects. They wanted to make sure that this building blended in with the Library of Congress next door and also with the Capitol.
For almost 150 years, the Supreme Court was basically homeless. The court met in New York City, Philadelphia, and then the old Senate chamber in Washington. Not until 1929 did then Chief Justice William Howard Taft finally convince Congress.
She said the old Senate chamber. It's a court chamber that was made for them down below. Whatever.
To fund construction of a permanent home. The building opened in 1935. Catherine Fitz is the head curator here.
Marble is most definitely the predominant material that's used. In fact, out of the original $9.7 million, they spent about $3.5 million just on the marble alone. The design for the building is a Greco-Roman temple, kind of a temple of justice.
Beautifully wood.
The High Court's associate curator, Matt Hofstad, then took us to the court's law library, an historic place where justices have long visited to consult the wisdom of justices past in the library's 600,000 volumes.
The library is a very vibrant part of what the court does because you need that sort of scholarly input in the opinion writing process.
Now, with the ease of the internet, the library isn't used nearly as much, but this room is a different story. It can never be replaced. The courtroom where historic cases such as Brown v. Board of Education, integrating public schools, Bush v. Gore, and many more have all been decided.
Oh, yay, oh, yay.
And the courtroom, in tradition and even furniture, has gone virtually unchanged since the first case was heard.
Some of the traditions you'll see here in the courtroom are the three justices come out in three groups from behind the red curtains. And some of the other traditions are, to this day, the court still puts quill pens at the desks of the attorneys who will be arguing before the court. Sort of a throwback to the John Marshall years.
Still, the justices are notoriously camera shy, and much of the government building, like their chambers, remains off limits. And while a grand building, we found the little details hidden from most visitors are what give the court's home its power and charm. Ornate carvings above the courtroom showing great lawgivers of the past, like Moses with the Ten Commandments and a rare image of the Prophet Muhammad. Small turtles on the lampposts outside signifying the deliberate pace of justice. And portraits of every former justice lining the walls where the new justices are sworn in.
This allows you to go through the history of the court in only 16 or 17 people. And we've had 44 presidents now. There's only been 17 chief justices in that same period of time.
An ever-evolving court, yet a place built on tradition and an institution leaving lasting imprints on the fabric of American society.
So they're important to us because of the fact that they interpret the law. And this is the highest level, obviously. But they have whole staffs. Understand, this is a huge building. Why do they have a huge building like that for 9 justices? They all have huge staffs to help them. They take about 80 cases a year. And they are petitioned with about 80,000 cases a year. So they have to kind of study the cases and then pick. The court goes from October to June. And usually at the end of June, they start handing down their decisions. So you'll see in the news, they start handing down decisions. Unless it's like they needed to get it out quicker. But things like gay marriage and stuff like that, it all came out in June. The big decisions come out in June. And you see how they ended up voting. And they don't always vote. They sometimes punt it back to the appellate courts. And then when they do vote on something, they explain it. So they produce a paper that explains why they voted the way they did, and they have a dissenting paper explaining why the judges that voted against it, even if it's just one, why they voted the way they did. So it's kind of cool. All right, so back to here. Again, there's the old chamber. And I got my pointer. The old chamber is where they worked for a long, long time until basically from 1815 to 1930. They were in this chamber here underneath, in the basement, the cellar dwellers of the Capitol building. And then in the 1930s, this took over. All right. So the Judiciary Act, which was passed by the first Congress, set up the court system. Another ingenious move by James Madison, because James Madison understood that you couldn't put into the Constitution all the details. Remember, if you looked at that, at the copy that I had of the Constitution in the back of the room, Article 1, Legislative Branch, it was huge. There was a lot of detail to it. It's how a bill becomes a law. We spent a lot of time on it. Article 2, a little bit longer than Article 3, but not as anywhere near as long as Article 1, the presidency. And then Article 3 is the shortest of the three branches. That's because James Madison understood that the country was going to grow, and that if you listed all the courts, it would become obsolete, and the Constitution would become obsolete. So acts of Congress can add more courts, more judges, and all that stuff. So that's how it's done. Their power is to interpret the laws of the nation, right? And it really is a pyramid. But at the top of the pyramid is the U.S. Supreme Court. Because we have federal law, you need regular courts, like Judge Judy kind of courts, or courts where people get arrested. The bomber in Boston, that was a federal case. And he went to a federal court. There was a jury. He was found guilty. And it was just like any other courtroom. States have courts because there's state laws. So Massachusetts has its own district courts. They have appellate courts. And there's even a state Supreme Court. That's where it gets really sticky and confusing. But the federal court kind of is the court of all the land. Yeah. So that's how it works. I'm going to go through these, and I might run out of time, but that's okay. So this is that pyramid, basically. The district court is the lowest level of the federal system. There's 94 judicial districts in 50 states and territories. They don't take appeals. They just rule if you're guilty or not, based on the law. And so that's it's regular courts. And then there's the appellate courts. That's when you appeal something based on there's something went wrong, either in your trial or there's something wrong with the law. And these are kind of like mini Supreme Courts. There's 3 judges that sit on them. They're all supervised by one of the Supreme Court justices. And there's 12 districts. It's kind of like Hunger Games regions. And then there's the Supreme Court. That's the last of the appellates, and they pick the ones. They go through a cert process. I can't say this word. That's Latin. All right. So let's start with the lower courts. There's 94 lower courts. They're the trial courts. They take criminal cases. That's when you've broken the law. That's what a criminal case is. And they take civil cases when your rights have been violated. So a civil case is when you are suing. And you can choose not to have a jury when you have a civil case. Then you end up before like Judge Judy, and she decides. I'm using Judge Judy, but because some of you have seen her. But criminal cases, most of the time, you always have the option of a jury. So it's probably better to have a jury. Usually get recommended by your lawyer. So criminal cases and civil cases, they hear over 300,000 cases a year. All right, and that's pretty accurate now. They're just normal courts. All the judges that are appointed on the district courts are appointed by the President of the United States. They're a lifetime. As they retire or die, the new president gets to appoint them. The Senate has to confirm them. Then this is the next level. This is the Circuit Court of Appeals. I have like the mini-me guy here because they remind me of the mini Supreme Court. They definitely make a lot of decisions that influence us every day. And a lot of times that's where it stops. It gets appealed to the appellate courts, and that's where they decide on whether or not the law is fair or whatever. There's 13 appellate courts. Judges decide if the district courts interpret the law incorrectly or if the law itself is right. There's 3 judges, and so there's a panel. And currently, there's a total of 179 appellate judges. This is the court that has been, because of during the Obama administration, his last 6 years, the Senate would not confirm any of his judges. There was a lot of judges a lot of seats that were empty. And President Trump has been able to put a lot of judges on this court. All right, good. And then, so this is what it kind of looks like. This is the, I told you it was like the Hunger Games. There's like, we're in the 1st district, so they break it up. And it's weird because the 9th district, if you look here, 9th district, they have 29 judges, 61 million people. That's a huge district. You know, our 1st district is almost 14 million people. It's not based on population, it's based on reachableness or something. And it can change. Again, that's the beauty of the Judiciary Acts, is that they could add a circuit. You know, I don't think they've added a circuit in my lifetime, but they have added a few circuits in my mom's lifetime. She's 88. All right, let me show you this website. I think this is. I think this is the one I wanted to show you. No, I don't know. Nope, nope, not that one, not that one. I don't think it's open. No idea. Let me hit it then. Sorry, I'm old. No, it's this one. Sorry. All right, so just showing you who's in charge of each of the districts. So Judge Roberts, who is the Chief Justice, is the District of Columbia because he's closest to there. Here's the map, and it kind of shows you. So Massachusetts, which is this district here, is Justice Breyer. Ginsburg is this district here. It tells you they supervise. I mean, there's in the other chart it showed you there's like 30, 40 judges, but there's one justice that supervises, and some of them have more than one district. That's all. It's not that important, but yeah. All right, highest court in the land, Supreme Court. They take about 80 cases a year, about 1% that are submitted to them, and they take the most controversial cases. They are the last court of appeal. I think I'm going to leave it there and finish this off on the next one, if I can get out of it. So if it gets to them, it's a pretty good deal. Let's do this because that makes sense. Well, at least in this video that kind of shows you how they take cases.
Easy to appeal to the Supreme Court, like when this lady wanted to fight her speeding ticket.
I am going to win this case. If not here, I'll appeal to a higher court. If necessary, I'll take it to the Supreme Court.
Or on Gilligan's Island, when Thurston Howell is locked in a bamboo jail and he says,
I'll take it to the Supreme Court.
But even though they make it sound like a right, nobody is entitled to an appearance at the Supreme Court. That's entirely at the discretion of the justices. And they choose very carefully. Only a small number of cases get to the Supreme Court, and it's getting smaller. Roughly 8,000 cases are submitted each year, but only 80 cases are accepted. That's a 1% acceptance rate. And to get to that 1%, most cases start at the bottom. The federal court system consists of 3 layers, and the lowest is the district level. If you lose in a district court, you can appeal to the circuit level. Most of the United States is divided into 11 circuits, but there's a 12th for DC and a federal circuit that mostly hears patent and military cases. Above the circuit level is the Supreme Court, the highest court in the land, as long as you don't count the basketball court that's above the Supreme Court. And to get to the Supreme Court, nearly all cases require submitting something called a petition for a writ of certiorari.
The writ of certiorari, which is shortened usually to writ of cert.
A petition for the writ of cert is a written request asking the Supreme Court to hear a case. Instead of asking the court to resolve the facts of a case, which are nearly always settled in lower courts, the reasons for granting the petition concern important questions about federal law.
The overarching goal of the court is to make sure that federal law is the same across the country. So by federal law, I mean the U.S. Constitution and laws passed by Congress.
Professor Green clerked for Justice John Paul Stevens, where he became very familiar with cert petitions. That's because the clerks review cert petitions for their justices, who then choose to grant a petition if it passes the rule of 4, meaning that 4 justices want to hear the case. When the court does not grant cert, it does not imply a decision.
It doesn't mean that it agrees with the lower court. It doesn't mean that the individual justices agree with the lower court decision. It just means that the court has decided that this particular case is not a case where the court is going to choose to set the law for the whole country.
If cert is granted, a case probably falls into one of 3 categories describing most Supreme Court cases. The first is a case of national importance, such as when the court decided Bush v. Gore in order to help determine who had won the 2000 presidential election.
Drawing on very rarely used legal powers, the Supreme Court has, for the first time in American history, decided to step into a legal dispute in the midst of a presidential election.
A second type of case is when a lower court issues a ruling that invalidates federal law. An example is Gonzalez v. Raich, in which Angel Raich, a California woman, challenged federal drug laws after agents destroyed marijuana plants she had been consuming for medical use. On her appeal in the Ninth Circuit, judges ruled in favor of Raich, deciding that she was compliant with the state law authorizing her use of medical pot. But that ruling conflicted with federal law prohibiting marijuana use.
So when the Ninth Circuit said it doesn't apply, that means if you're a medical marijuana user in California, then you can use it without fear of federal prosecution. But if you are a medical marijuana user in Florida or in New York, then it's still banned under federal law.
By ruling on the case, justices were able to establish the authority of federal law prohibiting the use of medical marijuana.
In the Reich case, the Supreme Court overruled the Ninth Circuit and said that the federal drug laws can apply to local marijuana use, which means that someone like Angel Reich can still be prosecuted under federal law, even though she can't be prosecuted under state law.
Third, the court accepts cases in order to resolve a split decision in the lower courts. This happened in the case of Obergefell v. Hodges, where a Sixth Circuit ruling that banned same-sex marriage conflicted with rulings in other circuits that had upheld the right to same-sex marriage.
The Obergefell was someone living in Ohio who wanted to marry his same-sex partner and was not permitted to do so under Ohio law. It made its way to the Sixth Circuit. The Sixth Circuit said you have no right to be married because you're a same-sex couple. And that created a split, a division of authority between the Sixth Circuit, which governs Ohio, and a number of other circuit courts. And so once that happened, it was fairly clear to, I think, most legal observers that the Supreme Court was likely to hear the case because it meant that federal law, the federal constitution in this case, applied differently in Ohio than it would in Pennsylvania, for example.
By ruling in favor of Obergefell, the court resolved a circuit split and made same-sex marriage a right nationwide. But these 3 categories are just a framework for understanding why the court might select a case. They are not rules. Ultimately, which cases get to the court depends on the decisions of individuals, the sitting justices of the U.S. Supreme Court.
All right, so that is very confusing, I know. But, you know, the idea of those 3 is huge. And how they can take a case if it's like a national importance case where, like, during an election in 2000 there was a judiciary snag and they had to get involved to make a decision so that we could finish the election. They can jump in to overturn law. They can say that the law is no good. That's called judicial review. And they can say that you can't, segregate children in schools, that it's not legal. And then the last case they can get involved in is when you have the districts the appellate courts are ruling differently, like on the same-sex marriage. 3 appellate courts had said it was okay for same-sex couples to get married. And then one said it wasn't. So the federal courts were split. So the Supreme Court kind of had to decide it. So that's it for today. It's getting beautiful out. Hopefully you're going outside and still staying on top of your virtual learning. It's almost done. Make sure you make up your April, May stuff by the 12th. And have a fun education day. We're going to go back, wash your hands, Don't touch your face. Be safe.